Morning, Chair and members. Jonathan Feldman with the California Police Chiefs Association in opposition to the bill. I want to start by saying CPCA supports accountability for constitutional violations. We always have. We do not defend bad officers, and we're not here defending the actions of federal officers. To the witness, you have my empathy for what you went through. Our concern is not with accountability. Our concern is with creating a brand new California cause of action that introduces significant legal uncertainty. Proponents have repeatedly stated that SB 747 is intended to mirror existing federal Section 1983 liability and preserve qualified immunity as it exists today. If that truly is the intent, the bill should expressly say so, and that is the nature of our opposition and the amendments that we put forward. The central question we have is who's going to define qualified immunity moving forward. Today, decades of federal precedent provide very well-established framework. SB 747, however, creates a new California cause of action that places the term qualified immunity into state law for the first time ever. It is not in statute, it is case law derived. Putting it into California state law for the first time opens the door to move away from decades of precedent. I think we all have realized that we're in a new era where judicial precedence doesn't mean what it exactly meant maybe years ago. And we have very limited faith that the statute is going to remain the same and not lead to significant changes in a legal term that has such resounding impact. Even a small tweak to the definition of qualified immunity has significant impacts to all of our public employees, not just law enforcement. Towards this issue, we have offered amendments that would stipulate that nothing in this section shall be construed to, quote, alter, limit, expand, or abrogate the doctrine of qualified immunity as recognized under federal law today. Again, if this is truly the intent of this bill, preserving existing federal standards should not be objectionable. Unfortunately, those amendments have not been accepted and our concerns have not been addressed. The bill also creates significant litigation exposure, combining a new cause of action with attorney's fees and additional costs, which are exacerbated by the bill's retroactive application, which allows a second bite at the apple in cases that have already been adjudicated, raising fundamental fairness concerns for public employees and local governments. Again, we have proposed narrow, targeted amendments that would provide certainty. We're willing to continue to work with the author and the sponsors and towards addressing our concerns. We also feel that the retroactivity piece should be expressly excluded in cases that have already been adjudicated. We appreciate the meetings that we've had thus far and the amendments that have been taken to address other concerns. However, our main concerns remain. We are adamantly opposed to the bill in print. Today, ask for your no vote.
Thank you.
David Mustagny on behalf of PORAC. And just to briefly follow up on my colleagues' concerns, with respect to qualified immunity, the concerns that both our clients have is that we don't have a watered down dual definition of qualified immunity. If you look at the wording of the statute, we view it as poorly drafted and we have offered amendments. It says that a defendant may assert qualified immunity. It doesn't have language that clearly indicates that qualified immunity will be tethered to federal standards and subject to the federal law. That's the amendments that we've put forward and that we ask for so that, again, everybody knows what the law is and that there's not a California standard of qualified immunity as well as a federal standard. Thank you.
Thank you. Is there anyone else here in opposition to SB 747?
Mr. Chair and members, Matthew Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs and the California Peace Officers Association, both opposed. Thank you.
Thank you.
Good morning, Mr. Chair. Member Shane Levine on behalf of the Fraternal Order of Police and the California Statewide Law Enforcement Association in opposition. Thank you.
Thank you.
Mr. Chair, Jolina Voris on behalf of the League of California Cities in respectful opposition. Thank you.
Thank you.
Mr. Chair, Ryan Sherman with the California Narcotic Officers Association and the Riverside Sheriff Association and the other law enforcement associations listed in the analysis, all in opposition. Thank you.
Thank you. Bring it back to committee. Assemblymember Pacheco.
Thank you. Thank you. And thank you to the author for bringing this bill forward. And also thank you for your witness for testifying. Thank you for being here in Sacramento. I know it's a long ways from Montebello. I'm in Downey, so I'm not too far from Montebello. So I want to thank you for being here and for sharing your story because it's horrible to see what's happening in our communities by immigration, law enforcement. Federal agencies are coming into our neighborhoods and they're terrorizing our neighborhoods. We've seen that in Downey, in Montebello, in Pico Rivera. We've seen it throughout Los Angeles County, and these officers need to be held accountable, and that's why this bill is important. but I also understand the concerns of the opposition. So I am supporting the bill today, of course, but I would like to see further conversations because I think we can perfect this bill even further. And I'll let you also make a comment, but I believe that we can perfect this bill. There's amendments that were offered, and I know maybe not all amendments can be taken, but I think maybe some of them to perfect it would be better, especially since our local state officers do not support what's happening in our communities, because what's happening is our residents now feel a distrust towards law enforcement because of what federal officers are doing, and that's not right. People should feel safe when going to their local police departments, and they should feel safe when talking to their officers, and they should not be terrorized. My dad speaks broken English, and it's hard for him to go outside, and I just always worry about him. But it's not our local law enforcement that are doing this. It's these federal officers. So we need to go after them. I agree. But if there's a way to perfect this bill, that would be amazing. And I think there is a pathway. And so, again, I am supporting the bill today, and I reserve my vote for when we get on the floor. But I know we can get to a good place. So if you want to make comments, I'll let you go ahead.
Yeah, no, I appreciate that. Assembly Member and you really, I think, very nicely articulated the problem that we're facing. That this is, and I've talked to a lot of local law enforcement, including ones who don't like this bill or didn't like the masking law that we passed. Because what ICE and Border Patrol is doing is harming local law enforcement. It's sweeping everyone in. And when you have these folks who are wearing these masks, not identifying themselves, or they just have police on there, so they're almost like impersonating local police officers, it creates a horrible situation for local law enforcement. And as you noted, destroys community trust in actual local law enforcement, and it's just horrific. We've been in ongoing conversations. I appreciate Mr. Feldman noting that we have taken amendments. I think some of the issues they've raised, I'm hopeful that there is a path. Some of them are more challenging, but we're going to continue those conversations, and we're committed to those conversations.
Assemblymember Zabur.
I just want to align my comments with those of Assemblymember Pacheco, and we'll be supporting the bill today, and appreciate the commitment to continue working with the opposition.
Assemblymember Bauer-Kahan.
Thank you. And I want to reiterate what my colleague from Downey said to you, Mr. Ramirez. Thank you for being here. It is painful, frankly, as Americans to watch what is happening in our state, in our country, and I'm sorry that we can't do more, and we're trying. And I want to thank the senator for trying, because you're right, nobody should be above the law. And I appreciate the opposition for, I think, acknowledging that. I think I just, yeah, just thank you for being here. It's really powerful. So I wanted to get a little bit at the amendment Mr. Feldman read, which was about the qualified immunity question. My guess, but I'm curious if this is the case, is that the problem with completely enshrining federal qualified immunity law is that currently, as I understand it, the federal courts have said that federal officers have immunity entirely, which would then enshrine that into this bill, which would get us back to where we are prior to this bill. But maybe I'm wrong about that. What is the problem with that?
No, the immunity entirely piece is that you simply can't, because the Bivens doctrine has been destroyed. So there really is no federal law, for the most part, that would allow you to sue a federal officer. So our goal here is there's an existing well-established body of law defining qualified immunity under Section 1983, and we are looking to import that into this cause of action. We're having ongoing conversations about the exact language. We want to make sure, we had some concerns about what they proposed for qualified immunity and what would define it. And they also appear to want to freeze frame it to what it is today. If the Supreme Court changes it tomorrow, we want qualified immunity to track whatever the state of the law is for Section 1983 claims as defined by the federal courts, because our goal here is just for everyone to be the same. Federal, state, local, to have the same liability standards, the same defenses, the same immunities, all the same. And we don't want to freeze frame that. So we're going to continue those conversations. But that's, I just want to let you know, like what our goal is.
Got it. And I imagine that would actually be beneficial to the opposition because the courts are fairly friendly right now. But I don't know if it's okay with Mr. Chair if the opposition's okay.
Yeah, we can continue to work on the language. It's not our intent to freeze it as it exists today, exactly, right? But just make sure that we're following precedential standards that were in place that officers are trained to and they understand. And it's a lot of what officers do on a daily basis, is informed by those standards. And we have to make sure that if we're going to make significant changes or any changes at all, we've got to be really careful about that.
No, I think that's fair. And I think we've had many qualified immunity conversations over my 8 years in this building. And to your point, this is delicate, but it's important that there is, where actions are as egregious as they are in this case, that there is a cause of action, right? And that includes all the qualified immunity that I think you guys are seeking. So I agree with my colleague from Downey that I think we can get there and appreciate the work that both the opposition and the author are putting into finding that common ground. And then the second question was on the retroactivity piece. I thought what the opposition said about cases that have had their day in court was a valid one. Again, I think you're most focused on those folks that can't get into court today. And so I understand the retroactivity piece as it relates to something that occurred in the past, but not for which there has been a claim filed. Will you touch on that?
I would say that would be a point to continue the conversations. I think where you'd want to be careful about just saying you can't have already filed a lawsuit is that some of the folks who've ended up in these awful situations have tried to file Bivens suits. And realistically, I think we all probably know how those are going to end. They're not squarely foreclosed by existing law, but to the extent they find success in the lower courts, they'll probably lose at the Supreme Court. And so I think you'd want to make sure that it was keyed in to make sure that if someone had filed a lawsuit under one of the more hopeless claims right now, you wouldn't be in a situation to be out of court where you'd actually have a good claim later. That would be distinguished from like if someone had already filed a 1983 suit and lost and like they'd already established a constitutional violation had not occurred. My guess is that there's various doctrines of preclusion that would prevent you from re-raising a constitutional claim that had already been adjudicated, but it's tough to speak in specifics.
And one of the complexities is that we have to treat everyone the same. And so that's an issue we're certainly happy to continue to look at.
Yeah, and I imagine that there's a way to thread that needle and deal with cases that have been decided on the merits, right? Which the cases that are thrown out based on the immunity that you're discussing would not have been decided on the merits of a constitutional claim. So I think there is a way to get to what you are both saying successfully, and that ensures that people who didn't get their day in court because they're being thrown out under current law will. Although it is an interesting question whether you would be able to bring a state, because this would be a separate cause of action that is now retroactive that didn't exist at the time. That seems like a very narrow legal question, and I'd be curious if there was precedent on that. But I think both of the points raised by the opposition seem like ones that, I'm hopeful you guys will continue, as you both said, to work on, and that we can get to a good place such that our law enforcement officers who are so critical to our communities and are doing, important work to keep us safe every day and are, there is current law. The Supreme Court hasn't found they can't be brought to suit under these laws. Don't see a patchwork, but we also are able to allow for individuals like Mr. Ramirez to get their day in court. So happy to support it today. And if it hasn't been moved, happy to move it.
And before the motion, just I believe we have an amendment for urgency, Senator. Amendment adding urgency.
Yes.
Okay. So with that amendment, a motion. Mm-hmm. Right. We have a motion in a second. Assemblymember Pappen.
Well, thank you, Chair. I'd like to thank the author and the opposition. And my colleague from Orinda did cover the legal points, although I will touch just a tad on the retroactivity. It would seem to me it would have to be a pending claim rather than something that's already been adjudicated. There's just no way. So hopefully you can work that part out. That seems very easy. The qualified immunity part, I hope you get there. It's very important. First of all, thank you for sharing your story, and I apologize for not saying that initially. I do consider the bill to be tremendously important, and I've supported your previous bills, the author's previous bills on the matter. Just on a personal note, my father was in the FBI, and I cannot help but think that he must be rolling over in his grave to hear stories like your witnesses. I mean, it is just unbelievable to me. And you got these guys representing a whole host of folks that are doing tremendous work in our state as state officers. But the federal situation has to be addressed. So it's not an easy one. And it's very painful for some of us to hear that our local law enforcement is struggling with this bill, because it seems like it should be something we get over the finish line. So like my colleague from Downey, let's get it over the finish line. It's tremendously important that the state of California doesn't have more likes of your witness. It was frightening to hear your testimony, but I thank you for making the effort to be here.
Madam Vice Chair.
Thank you, Mr. Chair. Senator, during your opening, you talked about that similar laws has been passed in, I believe, New York, Connecticut, and Vermont. Is that correct? Yeah. Have there been successful cases brought there, and can you tell me what the cause of action was or the results of those?
Those are very new laws. I don't know if Mr. Kistler may have more data about.
They're just new laws. I'm not aware of any case being brought under the New York, Connecticut, or Vermont statutes as of this date.
So they were signed last year, went into effect this year, or they're not even in effect yet?
It's different in each state. They were all signed this year. I think Vermont goes into, this is from memory, I think Vermont goes into effect on July 1st. New York, I think, is in effect now. It was signed by the governor as part of the budget package a couple weeks ago. And then Connecticut, I don't know the effective date on the Connecticut statute sitting right here, but it was passed and signed this year.
Okay. I'd be interested to see in the states that maybe are a little bit ahead of us, sounds like there's urgency now, what the success of those types of cases were. But thank you for that information. And then to my law enforcement friends, as the bill stands today, what do you think this does to qualified immunity for your officers as the bill's written right now without amendments?
The problem, as I said before, is that the language just says that you may assert qualified immunity. It doesn't define what the standard for qualified immunity is. And the amendments that we had proposed, and I'm actually quite pleased to hear that the senator seems to be in accord with us on wanting to tether it to the federal court standard. And we're, to be clear, not asking for it to be frozen in time, but to follow the federal case law, is simply to say that they will apply the identical federal standards and be bound by federal case law, so that you don't have a situation where qualified immunity means one thing in California and another thing in federal court.
So what potential impact do you think it could have to your officers is my question, I guess.
I think it's incredibly uncertain right now, but I feel certain that there will be a distinction made in California between what qualified immunity is here and what it is federally. And any change determines how officers respond to situations and scenarios, because, I mean, that's their livelihood, that's their lives, that's their freedom that's at stake, depending on what they are protected from and against. And if there's a change to it, I mean, you have to retrain every officer to that new standard. You know, we got 80,000 law enforcement officers in the state, retraining everyone on something like that, which is that important that we would have to. Very serious impact.
And potentially very serious impacts to our budget, our state budget that's already kind of in flux.
Possibly, if we have to start retraining officers to a new standard, yes.
And you might end up with inconsistent rulings too. If you, typically these types of cases, presumably you'd bring it under multiple statutes, like there's right now, if an officer is sued, a California officer or local officer is sued, they're sued under 1983, they're sued under the Bain Act, they're sued under the common torts, battery, false imprisonment, things of that nature. And so you want to have, I think it's important to remember what qualified immunity really is. It's saying that if an officer is confronted with circumstances where the law is not clearly established, that first officer confronting that situation gets qualified immunity. And once the law is clearly established, then no other officer does. And so it really comes down to, how do the courts define what clearly established is? And we need to have, in our view, one set of standards where this law in California would follow the same federal standards. And so officers and posts, when they're developing trainings, everybody knows what these terms mean and what the definitions are, and they follow the case law and the federal jurisprudence.
Okay, thank you, Mr. Chair.
Senator Wiener, did you have a comment on that?
Yeah, I just want to say, like, we've committed, we've been talking to law enforcement, we're going to continue to do that. We want everything to be drafted correctly and to be very tight, of course. I do have to just say, big picture, they're not going to have to retrain tens of thousands of officers. officers are intensively trained on following the U.S. Constitution. And that's what's at issue here, the U.S. Constitution. They received significant training in the academy, and I know that there's ongoing training. If there are changes in the law, they get automatically retrained. If there's a big change in the Fourth Amendment by the Supreme Court, for example, they'll be told about that. And so this is not a situation where there's like we're creating a brand new standard. No, it's the U.S. Constitution, and they are all. I can't state it enough. Right today, state and local officers can be sued under Section 1983 for the exact conduct that we're talking about here. If you shoot someone in the face, if you arrest someone for no reason, hold them for 5 days, and you're a local officer, you can be sued right now today, and that won't change under this law. Instead, it's going to apply to everyone. And so, again, we'll work on the technicalities and to make sure everything is tightly drafted, of course. But I do think that some of the opposition, in my humble opinion, with all respect, has been overstated. And this bill is even more important now because we saw what just happened in the United States Senate a few days ago, where they got around the filibuster with reconciliation to shove another, I think, $70 billion into the ICE slush fund. So ICE is now going to continue to get bigger with more untrained officers and more untrained Border Patrol officers who are going to come into communities and brutalize people. And so we need to get ahead of this, and that's why this bill is so important.
Any other questions or comments? Well, thank you, Senator, for bringing this forward, and I will reiterate the gratitude towards Mr. Ramirez for being here and telling your story, which unfortunately can be repeated far too often, not just here in California, but in all corners of this nation, particularly, unfortunately, in states like California. And also to reiterate the appreciation for local law enforcement. I know that our San Jose Police Chief has been very clear on the directives that our police department has and of our local law enforcement in not cooperating with federal immigration enforcement, and understanding how important that is for public safety for residents to understand that distinction and to know that their local law enforcement is there to protect everyone. And this is another example of legislation that we wish we wouldn't have to do under ordinary circumstances. Under bipartisan presidents, I think we've seen accountability of actions of federal agents. Unfortunately, right now, not only are we not seeing accountability, those federal agents are acting under the direction of our current administration to terrorize our community, and it's not fair or equitable to our state and local law enforcement that they can act with impunity. And I know a lot of local law enforcement don't appreciate the conduct of those federal agents, especially because it casts a negative light on law enforcement as a whole. When we know that it's the actions of those that are targeting our community, targeting our immigrant community, and are not being given the same training or oversight or accountability that every other law enforcement officer appropriately does and willingly does to effectuate public safety in our community. And so, as indicated by the senator, state and local law enforcement are already held accountable, and federal agents are not. The federal rulings on the Bain Act further exacerbate that. And I think it's incredibly, absolutely important that we have, access to justice for conduct that's being done by our federal agents, and to the retroactivity piece as well, especially if there's been claims been brought that have been dismissed out of hand because of lack of based upon the current state of the law, lack of ability to even bring these cases against federal agents. Those cases should not be limited, given what's happened over the last year and a half plus. And as it applies to and we're seeing this happen. I mean, and to the senator's point, I mean, right now, we have grave concern in my county, in South County and Santa Clara County, of an ICE detention facility being built with very little accountability or oversight that any other kind of facility would have to go through. So the reality is that, unfortunately, I don't think these actions are going to stop anytime soon. And so it's more important than ever that we do have our standards that we're able to apply to the actions of federal agents. And as it applies to qualified immunity, I mean, look, if there's a current state of qualified immunity or definitions or, that folks can agree on, that's one thing. But simply attaching it to federal law, when we see what the Supreme Court's doing right now, I would be very cautious about that, knowing the allegiance that the Supreme Court right now has to our federal administration. So if there can be some continued conversation of what qualified immunity means under ordinary circumstances that have been applied over many, many years, that's something I think that conversation should continue. But I would be very cautious about attaching it to changes in federal law that may be coming around the corner that we may not even be aware of at this moment, that could be detrimental to our ability to have true oversight over law enforcement, federal or otherwise. Would you like, I'd like to be added as a co-author, and would you like to close?
I think we've said it. Respectfully ask for an aye vote.
Thank you.
Motion is due passes amended, adding an urgency clause to appropriations. Calra?
Aye.
Calra, aye. Macedo? No. Macedo, no. Bauer Cahan? Aye. Bauer Cahan, aye. Bryan? Conley? Aye. Conley, aye. Dixon? No. Dixon, no. Harabedian? Pacheco? Aye. Pacheco, aye. Pappen? Aye. Pappen, aye. Sanchez? No. Sanchez, no. Stephanie? Zabur? Aye. Zabur, aye.
All right, please.